The hearing room smelled like floor wax and recycled air. A rear admiral was already seated at the head of the table when my name was read into the record. His aide leaned over and said something. The admiral laughed. Not loud, just a short, quiet sound, like something had mildly amused him. I looked at him across that table. He had no idea who I was. That was about to change. Let me take you back to the beginning. My name is Maya Reyes. I was 29 years old when this started, though it would take me nearly 2 years to finish it. I was a lieutenant in the United States Navy, assigned to Strike Fighter Squadron 31 at Naval Air Station Oceana, Virginia Beach, Virginia. I flew Super Hornets. My call sign was Ledger. I got that name 18 months into my first deployment in the Pacific, aboard the USS Theodore Roosevelt. Our squadron's logistics officer had been approving fuel requisitions that did not match actual flight hours. Small discrepancies, the kind that stop registering when you have been looking at the same spreadsheets for 6 months. I caught them on a Tuesday afternoon because I was bored and detail-oriented in equal measure. I mentioned it to my commanding officer. It turned out to be $41,000 in fraudulent billing going back 14 months. My commanding officer called me. Ledger in the debrief. The name stayed. I tell you that not because I want credit for it. I tell you because the call sign matters later. It matters in that hearing room, in a way I could not have planned. I grew up in Pensacola, Florida, in a neighborhood where every third house had a service flag in the window. My father, Chief Petty Officer retired Ernesto Reyes, had served 22 years in the Navy. He was quiet the way that certain men are quiet. Not from coldness, but from economy. He did not say things unless he meant them. He taught me to balance a checkbook when I was 9 years old. He taught me to notice when numbers did not match. He was the most honest person I have ever known, and I still believe that, even after everything I learned. My father remarried when I was 13. Her name was Darlene. I am going to be precise about what I mean when I talk about Darlene, because precision matters in a story like this. She was not cruel. She was strategic. There is a difference, and it took me a long time to understand it. I had no reason to think anything was wrong. That was the problem. My father's house was a 3-bedroom on Perdido Key, 7 minutes from the water. He had bought it in 1994 with a VA loan and paid it off 16 years later, which was the kind of thing that gave him visible, quiet satisfaction. The front porch had 2 metal chairs that had been painted white so many times the paint was thicker than the metal. He kept a jar of coins on the kitchen counter. He called it his fishing fund. The jar was never quite full and never quite empty. He fished off the pier on Saturday mornings. He called me on Sunday evenings, no matter where I was deployed. If I was in a communications blackout, he left a voicemail, always the same opening. "It's your dad, just checking in. I am telling you about that jar and those phone calls because I want you to understand what I had before this started. Not abstractly, not as background. That specific jar. Those specific calls." Darlene had a son from her first marriage, Marcus. He was 3 years younger than me and had never held a job for longer than 8 months at a stretch. I am not saying that to be unkind. I am saying it because it becomes relevant. Marcus was always on the edge of something, a new business venture, a new plan. There was always a reason things had not worked out yet, and it was never his reason. My father tolerated Marcus the way he tolerated bad weather, with patience and without illusions. He told me once, standing at the kitchen counter with a cup of coffee, "That boy is going to cost somebody something eventually. I just hope it is not us." I laughed. I should not have laughed. The first warning sign came in 2017, when I was home on shore leave and found a document on my father's desk. A consultation form from a law firm I did not recognize, with an address in Mobile, Alabama. I asked my father about it. He said it was nothing. That Darlene had wanted some questions answered about estate planning. He said he had not liked the attorney and was not going back. I believed him. Why would I not have? The second sign came 6 months later. My father mentioned, almost in passing during a Sunday call, that he had added Darlene to the deed. For convenience, he said. He said it the way people say things when they have already decided and do not want a discussion. I asked one question. He said it was fine. I let it go. Deployments have a way of making you accept the manageable over the urgent because you are already managing too many urgent things. The third sign came a year before everything broke. My father was diagnosed with stage 3 colon cancer. He did not tell me until 6 weeks after the diagnosis. Not because he wanted to protect me, he told me later, but because Darlene had said to wait, to let him process it first. I found out on a Sunday call in the spring of 2018 because he had missed 2 Sundays in a row and I had started calling the house directly instead. I found out later that while I was on that call, Marcus had already been meeting with a real estate attorney in Pensacola for 4 months. My father died on the 14th of March, 2019. I was over the Pacific, 6 hours into a combat air patrol, when my commanding officer reached me on the aircraft's secure communication system. You learn in this job to receive information without reacting to it in a way that compromises the mission. I received the information. I completed the patrol. I landed the aircraft. I walked to the locker room, sat down on the bench, and my hands went completely cold. Not from the temperature, just cold. I was back in Virginia Beach within 48 hours. The Navy handles emergency leave efficiently. I drove to Pensacola in 8 hours straight. Darlene was at the house when I arrived. Marcus was there. They were polite. Darlene hugged me in the way a person hugs someone when they are performing grief for witnesses. I noticed it. I filed it away. I was running on 4 hours of sleep, and I did not trust myself to interpret anything correctly in that state. So I noted it, just noted it, and kept moving. And my father's personal attorney, a man named Gerald Whitmore, called me 3 days after the funeral. He asked me to come to his office. He said my father had left a sealed document with him to be opened in the event of his death. I told him I would be there the next morning. Gerald Whitmore was 73 years old, had retired from a larger firm, and had known my father since the early 2000s. He was the kind of attorney who kept paper files in real folders and used a fountain pen. He handed me the envelope across the desk without preamble. I opened it. It was a letter, 4 pages, handwritten, in my father's small, precise print. I read it. I read it again. I set it down on the desk, and something cold settled behind my sternum and stayed there for 3 days. My father had written the letter 8 months before he died. In it, he described a quitclaim deed he had signed in the fall of 2018, transferring the Perdido Key property entirely to Darlene and Marcus as joint tenants. He had signed it, he wrote, after a long conversation with Darlene, during which she told him that I had agreed to this arrangement. That I had said, in a phone call she relayed to him, that I did not need the property. That I had my career and my housing allowance. That I wanted Marcus to have something to build on. I had never said that. I had never been part of any such phone call. I had never agreed to any such thing. My father wrote that he had tried to call me to confirm, but that his calls went to voicemail during a period when I was on restricted communications. By the time I was reachable, the deed was already signed. He had never asked me directly. He had trusted Darlene's account, and by the time he began to wonder whether he should have, he was already sick, and some part of him, I think, did not want to die knowing what she had done. He wrote that he was sorry. He said he believed I would know what to do with the information. That was why he was leaving it with Gerald and not with anyone else. I set the letter back on the desk. I looked at Gerald Whitmore. He looked at me. I said, "Quote 2. He said, "Quote 3, I said. Quote 4. That was the moment I stopped being upset. I started being methodical. They had no idea what they had just done, and I was going to let them keep not knowing. For a while. Now, at this point, I want to be clear about something. I did not walk out of Gerald Whitmore's office with a plan. I walked out with a letter, a legal question, and a very particular kind of stillness, the kind that anyone who has ever had to fly a damaged aircraft back to the carrier will recognize. Not calm exactly, but a precise understanding that being anything other than useful in that moment would cost me everything. What I had was a starting point. What I needed was evidence. And what I was about to discover over the following weeks was that my father's letter was not the only thing that Darlene and Marcus had failed to account for. There was something else. Something that would change the shape of this entire story. The first person I called was not an attorney. It was Commander Retired Patricia Okafor, who had been my squadron's executive officer during my first deployment and was now teaching contract law at the Naval Postgraduate School in Monterey, California. I had her personal number because she had given it to me after the fuel requisition incident, along with a short, precise sentence that I had not forgotten. People who notice things need people they can call. I called her from the parking lot of Gerald Whitmore's office, sitting in my rental car with the windows up. Patricia Okafor did not express sympathy when I told her what had happened. She asked 4 questions. She asked for the state of record. Florida. She asked whether the deed had been notarized. Yes. She asked whether my father had been represented by independent counsel at signing. No. She asked whether I had the letter in my physical possession. Yes. Then she said, quote, 6. I asked her how I demonstrated that. She said, quote, 7. I said, quote, 8. She said, quote, 9. Then she said one more thing, in the dry, unhurried tone that had made her the best dealing officer I've ever known. I thanked her. She said, I called Gerald Whitmore from the car and asked him for a referral to a probate litigator. He gave me 2 names. The second one was a woman named Constance Beaumont, who had been practicing estate litigation in Florida for 26 years and had handled 11 undue influence cases, winning 9 of them outright and settling the other 2 on terms favorable to her clients. I know those numbers because she told them to me at our first meeting, without being asked, in the same tone a flight surgeon recites medication dosages. She was 54 years old, wore reading glasses on a chain around her neck, and spoke in short, declarative sentences that I appreciated immediately. She reviewed my father's letter and said, "This is a strong foundation and it is not enough." I said, "I know, what do I need?" She laid it out. First, I needed documentation of my deployment communications blackout for the period in question to directly contradict Darlene's claimed phone call. Second, I needed the notary record for the quitclaim deed to examine the circumstances of signing. Third, I needed any witnesses who were present at or around the signing. Fourth, if possible, I needed evidence of Darlene's intent prior to the signing. Any communications, searches, consultations. Anything that showed this was planned rather than spontaneous. I spent the next 6 weeks gathering all of it. My official orders and communication logs for September 2018 took 4 days to obtain through my command. The records showed 19 consecutive days of restricted communications beginning September 3rd. No outgoing personal calls, no incoming personal calls. The window Darlene had used was the exact window in which she claimed I had called and agreed. My personal phone records from the surrounding months required a written request to my carrier and took 11 days. I went through them line by line. I had called my father 16 times in the 60 days surrounding that period. I had never called Darlene directly, not once. In 3 years of records, I had called the house number 7 times, always when my father did not answer his cell. There was no call to any number associated with Darlene or Marcus during the blackout period before it or after it that could be construed as a conversation about the property. The notary record was where things got complicated. The deed had been notarized by a woman named Sylvia Greer, who operated a mobile notary service out of Escambia County. Constance subpoenaed her records. Sylvia Greer had notarized the document at my father's home address on a Tuesday afternoon in late September. The record listed two signatories, my father and Darlene. What it also listed, in a field that most people do not read, was the identification presented. My father had presented his retired military identification card. Darlene had presented a Florida driver's license. Standard. Unremarkable. Except that in the notary's handwritten notes, which Sylvia Greer kept in a personal logbook she had maintained for 19 years, there was a single line. It said, underscore underscore, quote underscore 14, underscore underscore. Constance read that line to me across her desk. She took off her reading glasses. She put them back on. She said, underscore underscore, quote underscore 15, underscore underscore. Then I pulled the county records, and I saw the date, and I had to sit down. The quitclaim deed had been filed with the Escambia County Clerk of Courts on the 29th of September, 2018. My father had been diagnosed with cancer on the 18th of July, 2018. The deed was signed and filed 11 weeks after his diagnosis, 11 weeks after Darlene knew with certainty that my father's window was limited. Constance had told me that timing alone did not prove undue influence, but that timing combined with the notary's note, combined with the false representation, was the architecture of a case. The unexpected piece came not from any record I requested, but from a man named Roy Delacroix, who had been my father's neighbor on Perdido Key for 14 years. Roy was 71 years old, a retired Gulf Coast fisheries inspector, and he called Gerald Whitmore's office 6 weeks into my evidence collection because he had heard through a mutual acquaintance that there was a legal matter involving my father's property. He said he had information he thought might be relevant. Roy had been on his porch on the afternoon the notary visited. He had seen Sylvia Greer's car in the driveway. He had seen my father walk out to the porch midway through the appointment, stand there for several minutes looking at the water, and then go back inside. He had not thought much of it at the time, but he had also, 2 days before the appointment, been present for a conversation at my father's kitchen table, a conversation he had stumbled into while returning a borrowed tool in which Darlene told my father, with Marcus sitting beside her, that I had spoken to her directly and said I thought the transfer made sense, given that I was never home and never going to settle in Pensacola anyway. Roy had not known whether that was true. He had thought it was my father's business, but he had remembered the conversation because something about it had felt rehearsed to him, and because my father had not said anything during it, had just sat with his hands around his coffee cup and nodded slowly, the way a man nods when he is too tired to argue and too proud to say so. Roy told me this in Constance's conference room, in a plain gray office chair, with his hands on his knees and a directness I was grateful for. When he finished, he said, "Your dad talked about you all the time. He was proud of that call sign. He used to say it like it meant something." He paused. "I figured you should know what I saw." I thanked him. He waved it off and said he had never liked Marcus much anyway, which was the first time I had smiled in 6 weeks. 2 days later, Darlene's attorney made contact. He offered a settlement, a cash payment of $42,000 in exchange for my releasing all claims to the property. The property had been appraised the previous year at $380,000. Constance looked at me when we got off the call. I said, quote 18. She said, quote 19. I said, quote 20. I want to pause here for a second, because at this point I had everything I needed. Every document, every witness, every date. I had built something that could not be argued with. And I remember Constance Beaumont looking at me across her desk and saying, and I am going to quote her exactly, underscore underscore quote, underscore 21, underscore underscore. And I understood exactly what she meant, because I had been in rooms like that before. Rooms where the person across the table has already written the outcome in their head. And I knew what that kind of confidence looks like right before the floor comes out from under it. What I had not told Constance yet was the last piece. The piece I had been sitting with for 2 weeks, turning over, making sure I understood it correctly before I said it out loud to anyone. When I had requested my father's complete medical records as part of the estate documentation, I had received a file that included his oncology consultations, his treatment notes, and his prescriptions. One of the prescriptions caught my attention. Not because I am a doctor, but because I am someone who reads documentation carefully, and because the medication name was one I recognized from a naval medical briefing I had attended 3 years earlier on cognitive effects of long-term opioid pain management. My father had been prescribed a high-dose opioid pain medication beginning in August of 2018, 6 weeks before the deed was signed. The oncology notes from his September appointment described him as, and I am reading from the document directly, oriented but fatigued, occasionally slow to process complex information, appropriate for current medication regimen. The deed was signed during that appointment window, during a period in which his treating physician had documented in writing that he was slow to process complex information. But here is what none of them knew. I had obtained those records legitimately, as a direct family member and named party in the estate. They had not known I would request them. They had not known the oncology notes existed in a format accessible to me. And they had certainly not known that the notary's personal logbook, 19 years of handwritten notes, was going to say what it said. I need you to understand what that combination of documents actually meant. It meant that on the day my father signed that deed, there was a physician's note in his medical file documenting impaired cognition. There was a notary's personal log documenting visible confusion, and there was a neighbor who had witnessed the false representation made to my father 2 days earlier. Wait, it gets worse. When Constance cross-referenced the timeline, she found that Marcus had filed for a contractor's business license in Escambia County on the 2nd of October, 2018, 3 days after the deed was filed. He had listed the Perdido Key address as the business's primary asset collateral. He had started building on the property before my father was even in the ground. The attorney went very quiet when Constance called him with the full document package. I was in the room. I watched him go silent on the speakerphone for 4 seconds. That is a long silence on a legal call. I had one meeting left, and I had been waiting for it. Everything I had done for the past 3 months had been preparation for one room, one table, one conversation. Constance told me to let her lead. I told her I understood, and I did understand. I just also knew that there was one moment, one specific moment, when I was going to say something. One sentence. I had been thinking about it for 11 weeks. I knew exactly when to say it, and I knew exactly what would happen after I did. We pulled into the parking garage at 8:47 in the morning. I remember checking the time. The probate hearing was held in a conference room on the 4th floor of a courthouse in Pensacola, Florida, on a Thursday morning in November. The room had a long table, 8 chairs, 2 windows that faced a parking structure, and overhead lighting that gave everything a faint yellow cast. It smelled like floor wax and recycled air, the same smell as every institutional room I had ever sat in, and I found that steady. Constance and I arrived 7 minutes early. Darlene and Marcus were already seated on the far side of the table with their attorney, a man named Philip Stout, who had the practiced ease of someone accustomed to being the smartest person in a room. Beside him sat a man I did not recognize, in civilian clothes, but with the posture that does not leave you when you leave the service. Constance's paralegal had told us the previous afternoon that Darlene had arranged for a character witness, a rear admiral named Thomas Garfield, retired, who had apparently known my father through the Pensacola veteran community and was there to speak to my father's sound judgment and his close relationship with Darlene. When I walked in, Darlene looked at me once and then looked away. Marcus looked at the table. Philip Stout looked at me the way attorneys look at opposing parties when they have already written the outcome in their notes. The Admiral looked at me the way some senior officers look at junior ones when they have not yet decided whether the junior one is worth their attention. The hearing was administered by a probate magistrate named Judge Carla Sims, who ran her courtroom with the economy of someone who had seen every version of every family dispute and had long since stopped being surprised by any of them. When she read my name into the record, she also read my rank and service assignment. And then she read my call sign, because it was on the service documentation Constance had submitted as part of establishing my identity and credibility as a witness. The Admiral's aide leaned over when she said it. The Admiral made a short, quiet sound. Not loud, just amused. Ledger. I heard it. Constance heard it. Judge Sims, to her credit, did not look up. I sat down. I placed my folder on the table in front of me. I did not look at the Admiral again. Philip Stout opened by presenting the deed as a straightforward estate instrument, voluntarily signed by a mentally competent adult who had full understanding of its implications. He described my father as a man who had made a considered decision to provide for his wife and her son. He described me as an adult child who had been largely absent from her father's life due to her military service, and who had no claim on decisions made by a competent man in his own home. He said this pleasantly. He said it the way people say things they believe cannot be contested. I sat and let him say it. Judge Sims asked Philip Stout whether he was prepared to address the question of the communications blackout. He said that a verbal agreement could have been reached before the blackout period and conveyed to my father afterward by Darlene directly. He said there was no documentation either way. He said that last sentence with particular confidence. He believed it was true. Constance waited 2 seconds after he finished. Then she opened her own folder and placed 5 documents on the table, fanned slightly so their contents were visible to the magistrate. She did not say anything immediately. She let Judge Sims pick up the first one. I watched the room in the 5 seconds after that. Philip Stout's hand, which had been resting flat on the table, moved to his pen. He picked it up and set it back down. Marcus looked at the documents and then at his mother. Darlene's expression did not change, but the muscles around her jaw tightened in a way that had nothing to do with emotion and everything to do with calculation. The Admiral looked at his aide. His aide looked at the documents. Neither of them said anything. Judge Sims read the first document, which was the communication log from my command showing the 19-day blackout. She read the second document, which was my personal phone records showing no call to Darlene or Marcus during or surrounding that period. She picked up the third document, which was the notary's log entry. She read it twice. She set it down and looked at Philip Stout over her reading glasses and said, "Counsel, your client's deed was signed during a period in which the signatory's treating physician documented impaired cognition. Are you prepared to address that?" Philip Stout said, "I would need to review the document." Constance slid him a copy. The room went quiet in a particular way, not the quiet of people waiting for someone to speak, but the quiet of people recalculating. Judge Sims asked whether there was a witness present who had observed the circumstances of the signing. Roy Delacroix was seated in a chair along the wall. He stood, confirmed his name and address, and described what he had seen and heard at my father's kitchen table 2 days before the deed was signed. He spoke for 4 minutes. He did not embellish. He did not look at Darlene while he spoke, not because he was avoiding her, but because he was talking to the magistrate and he understood that was who mattered. When Roy finished, Philip Stout began to say something about the reliability of a 14-year-old casual observation. Judge Sims held up one hand. She was looking at the 5th document, which was the oncology note. She read it carefully. She set it down. She looked at Darlene. She said, quote, _25_. During the recess, Marcus stood up and walked to the window. He stood there with his hands in his pockets looking at the parking structure. Darlene spoke quietly to Philip Stout. I sat at the table with my hands folded and did not move. The Admiral walked to where I was sitting. He stood beside my chair. He said, in a voice low enough that it did not carry across the room, quote, 26. I looked up at him. I said, quote, 27. I paused. Quote, 28. He looked at me for a moment. Then he looked at Darlene. Then he looked back at me. He did not say anything after that. He walked back to his chair, sat down, and did not speak again for the remainder of the hearing. When Judge Sims returned, she stated for the record that the preponderance of evidence supported a finding of undue influence and material misrepresentation in the execution of the quitclaim deed. She voided the deed. The property reverted to my father's estate, of which I was the sole heir. She referred the matter to the state attorney's office for review of potential elder abuse statutes. Philip Stout requested time to file a response. Judge Sims said he was welcome to do so. The room was very quiet. Outside, through the window, I could hear traffic. Someone's phone buzzed on the table and nobody moved to answer it. I walked to the parking garage alone. I took the stairs. On the second landing, I stopped, put my back against the wall, and stood there for about 60 seconds. I did not cry. I did not feel triumphant. I felt something closer to the feeling after a long flight, when the aircraft is down and secured, and the adrenaline is leaving your system and your body is just tired in a clean, finished way. I stood there until that feeling settled. Then I walked to the car. Philip Stout withdrew from representation 2 weeks later. Marcus and Darlene did not contest the ruling. The state attorney's office opened a preliminary review that ultimately resulted in a civil elder abuse finding. There was no criminal charge, which Constance had told me to expect. The finding meant that the record existed. It meant that what they did had a name in an official document, and that document would follow them. Marcus lost the contractor's license application. The property was returned to the estate and, through probate, to me. I did not sell it immediately. I am not sure I will. Darlene called me once, 8 weeks after the hearing. I answered because I wanted to hear what she would say. She said she had believed it was what my father wanted. She said things had gotten complicated. She said she hoped I could understand that it was a difficult time for everyone. There was a long pause after that, and I did not fill it. Eventually, she said she supposed there was nothing else to say. I agreed with her, and we hung up. It was not satisfying in the way I had expected. She was not asking for forgiveness. She was looking for a version of events she could live inside of. I could not give her one, and I did not try. Roy Delacroix and I have had coffee twice since then. He still fishes on Saturday mornings. He asked me once if I was going to keep the house. I said I did not know yet. He said my father used to sit on that porch in the evenings and watch the light change on the water, and that he had seemed most like himself in those moments. I wrote that down later in the margin of a notebook I keep. I do not know exactly why, except that it felt like something I did not want to lose. Constance shook my hand outside the courthouse. She said, "Good work." That was all. It was enough. My father's coin jar is on my kitchen counter in Virginia Beach now. It came to me with the estate. There are still coins in it, quarters mostly, and a few old pennies. I have not added to it, and I have not emptied it. It sits there on the counter next to the coffee maker. And sometimes in the morning I look at it for a moment before I do anything else. That is where I am now, 2 years out. I am still flying. I was promoted to lieutenant commander in the spring. I run 3 miles before work on mornings when the weather allows it, and on the mornings when it does not, I run them anyway. I am working on a graduate certificate in contract law through an online program, which Patricia Okafor told me would be useful, and which I am finding she was right about. My father's name is Ernesto Reyes. He served 22 years. He taught me to read numbers carefully and to say what I meant, and to notice when something did not add up. He trusted the wrong person once, at the end, when he was tired and in pain, and trying to hold things together without worrying his daughter. for trusting that I would know what to do with it, for being, in the end, still himself. There is one more thing I have not told you yet. The probate record is public. Anyone can look it up. The finding of undue influence, the voided deed, the elder abuse review. It is all there, attached to the address on Perdido Key, attached to their names. It will be there when Marcus applies for the next business license. It will be there when Darlene applies for anything that requires a background check on property history. I did not put it there to punish them. I put it there because the truth of what happened to my father deserved to exist somewhere outside of a sealed envelope in a lawyer's drawer. The jar is still on the counter, still about half full. I have not decided what the fishing fund is for yet, but I have not thrown it away either. If any part of this story felt familiar to you, I would want to hear about it in the comments. And if you want to know what happened with the state attorney's review after this, there is more to this story.